Good day to everyone. For this video, we are going to discuss in question and answer format the rules on the issuance of search warrants. This is based on Rule 126 of the Revised Rules on Criminal Procedure and related jurisprudence. I will also discuss here the new rule on the use of body-worn cameras in the execution of search warrants, as the use of a body-worn camera is now required under Supreme Court Administrative Matter number 21-06-08. So let's start the rolling. What is a search warrant? A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer commanding him to search for personal property described therein and bring it before the court. This is found in Rule 126, Section 1 of the Revised Rules on Criminal Procedure. When you say order in writing, it means a written order. A verbal order, therefore, is void. And when you say in the name of the people of the Philippines, it is because it is the state that intrudes into a person's privacy or the privacy of one's abode. And when you say signed by a judge, it is only a judge who can issue a search warrant. And when you say directed to a peace officer, only a public officer vested with authority to effect arrests or implement searches can implement a search warrant. What about personal property? Personal property are those enumerated in Articles 416 to 418 of the Civil Code, but in general they refer to all things which can be transported from place to place, or they may also refer to any property which is not included in the enumeration of real properties in Article 415 of the Civil Code. But in the case of Laod versus People, the Supreme Court said that personal property for purposes of or in reference to the issuance of a search warrant actually refers to the thing's mobility and not to its capacity to be owned or alienated by a particular person. Okay. Articles 416 to 418 refer to its capacity to be owned or alienated by a particular person. In relation to a search warrant, personal property refer to things that bear a direct relation to the offense committed. Like, for example, a search warrant relating to the search or recovery of human remains of people subject of salvagings. Even if human remains are not personal property per se, or they are not personal property in the sense of Articles 416 to 418 of the Civil Code, but for purposes of or in connection with the issuance of a search warrant, they are subsumed under the phrase personal property because human remains bear a direct relation to the offense committed. In that case, the offense committed was murder, and the police officers applied for a search warrant to recover human remains of people that were allegedly salvaged. What is the purpose for issuing a search warrant? It is for the purpose of searching and seizing personal property, either personal property subject of the offense, or personal property stolen or embezzled and other proceeds or fruits of the offense, or it could be personal property used or intended to be used as the means of committing an offense. This is found in Rule 126, Section 3 of the Revised Rules on Criminal Procedure. When you say personal property subject of the offense, an example of this can be illegal drugs in the possession of a drug pusher, stolen or embezzled and other proceeds or fruits of the offense. An example of this can be the car stolen by a carnapper. And when you say personal property used or intended to be used as the means of committing an offense, an example of this can be the firearms and explosives in the possession of a suspected terrorist. Now, why would a judge issue a search warrant? The judge does not motu proprio or on his own issue a search warrant. It must be applied for by the public officer who has knowledge of facts personally known to him that the things to be seized are in the place sought to be searched. In the case of Pilipinas Shell Petroleum Corporation versus Romars International Gases Corporation, the Supreme Court clarified that a search warrant merely constitutes a process. It is not a criminal action in itself. At the time a search warrant is applied for, or at the time a search warrant is issued, there is yet no criminal case or criminal action pending in court in connection with that search warrant. It is only after the search warrant turns out successful because, like for example, the police officers were able to recover personal properties subject of the offense, that they will be filing a criminal action against the person in possession of the said personal properties. Because a search warrant is akin to a writ of discovery. It is a special and peculiar remedy, drastic in nature, and made necessary because of public necessity. Now, against whom should the application for a search warrant be filed? It should be filed against the person in actual possession or against the person who has constructive possession of the place where the things to be seized are located or stored. Possession under the law includes not only actual possession but also constructive possession. Actual possession exists when the drug is in the immediate possession or control of the accused. For example, X placed the sachets of shabu inside the small bag he was carrying. On the other hand, constructive possession exists when he has the right to exercise dominion and control over the place, room, house, or building where the illegal drug is found. Example, the shabu found inside the room where X is staying. Exclusive possession or control is not necessary. Take note of this. The accused cannot avoid conviction if his right to exercise control and dominion over the place where the contraband is located is shared with another. So for example, the accused is sharing a room with another person, and the application for a search warrant states that the contraband is located in the room where the accused is staying, although in that room it is being shared with another person. By itself will not invalidate the search warrant because, to repeat, as ruled in the case of People versus Trinidad, exclusive possession or control is not necessary. If the implementation of the search warrant turns out successful, what happens next? If the person subject of the search warrant was present during the implementation, then he will be arrested, this even without a warrant of arrest, because this is an example of a valid warrantless arrest. And he will then be subjected to an inquest proceeding. You already know what an inquest proceeding is, as I have already discussed in my previous video. For example, the 2 kilos of shabu was found in X's house. X was present during the implementation of the search warrant. Here, X will be arrested and a criminal complaint will be filed against X before the fiscal, who will then conduct an inquest proceeding. If X in the example was not around during the said implementation, a criminal complaint will still be filed against X, but this time under the regular preliminary investigation procedure as found in Rule 112, Section 3 of the Revised Rules on Criminal Procedure. Here, the police officers who implemented the warrant will file a complaint against X before the fiscal. The fiscal will then issue a subpoena requiring X to submit his counter affidavit within 10 days from service. Within 2 months from the filing of the complaint, the fiscal will then have to issue a resolution whether or not to file an information or a criminal case against X. So I'm just giving you a synopsis of what happens in a preliminary investigation procedure. What shall the police officers do with the property seized? The officer seizing property under the warrant must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. This is so provided in Rule 126, Section 11 of the Revised Rules on Criminal Procedure. So here, after the seizing officer is able to seize the personal property described in the warrant, he is mandated by the rule to issue and give a detailed receipt to the lawful occupant. A receipt is basically a listing down of the personal property or properties recovered or seized from the house of the lawful occupant. Or if the lawful occupant is not around at the time of the search, then the police officer will still be obliged to issue a receipt, but this time he may leave such receipt in the place in which he found the seized property, provided that it must be made in the presence of at least 2 witnesses of sufficient age and discretion residing in that area or locality. What I mean by this is that the 2-witness rule or the requirement of 2 witnesses will only be had if the lawful occupant is not present at the time of the search. Because if the lawful occupant was present at the time of the search, then the 2 witnesses will no longer be necessary. Moreover, the police officers who implemented the search warrant must forthwith make a return on the search warrant and deliver the property seized to the judge who issued the same, together with a true inventory thereof duly verified under oath. So aside from issuing and giving a receipt, the police officer also must forthwith, meaning immediately or right away, make a return on the search warrant and deliver the property to the judge who issued the search warrant. A return is basically report in writing to be made by the police officer for the purpose of informing the judge on the outcome or result of the implementation. So, as I said, aside from issuing and giving or leaving a receipt, the police officer who implemented the search warrant must also make a report to the court, and at the same time, forthwith or immediately deliver the property seized to the judge who issued the said warrant, and attached therewith or together with the personal property seized, submit a true inventory of the personal property seized. Now, oftentimes, the receipt and the inventory are embodied in one document. So, the police officer may only need to furnish the same copy of the receipt to the issuing court. Because as I said, the receipt and the inventory are usually embodied in the same or contained in one or the same document. And when you say true inventory, it is also the listing down of all the properties seized in connection with the enforcement of the search warrant. If the implementation of the search warrant is not successful, meaning there was no, or the police officer implementing the search warrant was not able to recover or seize the personal property described in the search warrant, what happens next? The person subject of the search warrant cannot be arrested and no criminal charge can be filed against him because why? Why? The police officer was not able to recover property subject of the offense, for example. So how can there be a case filed against the person subject of the warrant when no personal property described in the said warrant was recovered or seized at the time of the implementation? But just the same, the police officer who implemented the search warrant must still forthwith make a return thereof. So yung isasubmit ng police officer, return na lang. Wala na siyang maisasubmit na personal property or inventory because there was no property that was seized or recovered in the first place. What are the duties of the judge who issued the search warrant? 10 days after the issuance of the search warrant, the issuing judge shall ascertain if the return has been made, and if none, shall summon the person to whom the warrant was issued and shall require him to explain why no return was made. If the return has been made, the judge shall ascertain whether or not Section 11 of Rule 126 has been complied with and shall require that the property seized be delivered to him. The judge shall see to it that Section 12A of the same rule has been complied with. Now, if the police officers fail to, number one, give a detailed receipt or leave a receipt, or if the police officer or officers fail to deliver forthwith the property seized together with the inventory thereof, or if the police officer or officers fail to explain why no return has been made, or if the police officer or officers fail to make a return on the search warrant, the same shall constitute contempt of court under Rule 126, Section 12. How many days is a search warrant valid? A search warrant shall be valid for 10 days from its date, meaning the date stated in the search warrant. Take note, 10 days from its date, not 10 days from receipt by the officer to whom the warrant is issued. And after 10 days, it shall be void. It is non-extendable. If the search warrant is implemented, let's say 11 days after its issuance, any personal property seized in connection therewith becomes inadmissible for any purpose in any proceeding. Reason? The search warrant at the time of the seizure has already become void, such that even if, let's say, contraband was searched or the prohibited articles described in the warrant was discovered by the police officer concerned and seized thereafter, that will not be used against the person subject of the search warrant. No criminal case will be filed against that person. And on the contrary, it will be the officer who implemented a void search warrant will be subjected to criminal liability. And what is that criminal liability? That officer will be held criminally liable for violation of domicile under Article 128. Now, at what time must the search be made? The warrant must direct that it be served in the daytime. So the general rule here is a search warrant must be served in the daytime. Unless the affidavit, referring to the affidavit of the applicant or the affidavit of the witness or witnesses of the applicant, asserts or assert that the property is on the person himself or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. What does this mean? The warrant must state that the same may be served at any time of the day or at any time of the night because of the circumstance mentioned in Rule 126, Section 9. Can the police officer break open any door or window or any part of a house to effect the search? The answer is yes. The officer, if refused admittance to the place of directed search after giving notice of his purpose and authority, may break open any outer or inner door or window of a house or any part of a house or anything therein to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. Should there be witnesses other than the police officers during the search? The answer is yes. Under Rule 126, Section 8, no search of a house, room, or any other premise shall be made except in the presence of the lawful occupant thereof or any member of his family or in the absence of the latter, two witnesses of sufficient age and discretion residing in the same locality. A violation of this rule will make the officers liable under Article 130, searching domicile without witnesses. When you say lawful occupant, it refers to the person whose domicile, papers, or effects are subject of the search. What about the phrase two witnesses of sufficient age and discretion? Since the rule mentions two witnesses, it must be two, not one. And a person of sufficient age and discretion is one who has attained the age of 18 and is considered to have enough discernment. Discretion is defined as the ability to make decisions which represent a responsible choice and for which an understanding of what is lawful, right, or wise may be presupposed. So, the definition or description rather of the phrase two witnesses of sufficient age and discretion was given in the case of Prudential Bank versus McDermott Jr. Where shall an application for search warrant be filed and in what court? Rule 126 Section 2 provides that an application for search warrant shall be filed in number 1, any court within whose territorial jurisdiction a crime was committed, or number 2, for compelling reasons stated in the application, any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed, the application can only be made in number 3, the court where the criminal action is pending. The phrase any court within whose territorial jurisdiction the crime was committed refers to either the regional trial court, or the next lower courts like the MTC, MTCC, MCTC, and Metropolitan Court, or any court for that matter that has jurisdiction over the place where the alleged crime was committed. For example, if the crime happened in Ormoc City, it will be the RTC or the MTCC of Ormoc City that may or that can act on the application. It must be noted that nothing in the above quoted rule does it say that the court issuing a search warrant must also have jurisdiction over the offense. A search warrant may be issued by any court pursuant to Rule 126, Section 2 of the Revised Rules on Criminal Procedure, and the resultant case may be filed in another court that this time has jurisdiction over the offense committed. Why? Because what controls is that a search warrant is merely a process. I already emphasized this in the previous slide. It is merely a process generally issued by a court in the exercise of its ancillary jurisdiction and not a criminal action to be entertained by a court pursuant to its original jurisdiction. Hence, in certain cases when no criminal action has yet been filed, any court for that matter may issue a search warrant even though it has no jurisdiction over the offense allegedly committed, provided that all the requirements for the issuance of such warrant are present. This is the case of People versus Honorable Castillo Sr. For example, the MTC has the authority to issue a search warrant involving an offense in which it has no jurisdiction, like a search warrant for illegal drugs. Note number 1. The concept of venue of actions in criminal cases, unlike in civil cases, is jurisdictional. The place where the crime was committed determines not only the venue of the action, but is an essential element of jurisdiction also. It is a fundamental rule that for jurisdiction to be acquired by courts in criminal cases, the offense should have been committed or any one of its essential ingredients should have taken place within the territorial jurisdiction of the court. Territorial jurisdiction in criminal cases is the territory where the court has jurisdiction to take cognizance or to try the offense allegedly committed therein by the accused. Thus, it cannot take jurisdiction over a person charged with an offense allegedly committed outside of that limited territory. Just to emphasize again, an application for a search warrant is a special criminal process rather than a criminal action. We should not equate the application for and the obtention of a search warrant with the institution and prosecution of a criminal action in a trial court. The requisites, procedure, and purpose for the issuance of a search warrant are completely different from those for the institution of a criminal action. Applications for search warrants are not criminal actions themselves. A search warrant merely constitutes a process, generally issued by a court in the exercise of its ancillary jurisdiction and not a criminal action to be entertained by a court pursuant to its original jurisdiction. Proceedings for said applications are not criminal in nature, and thus the rule that venue is jurisdictional does not apply thereto. Now, the phrase compelling reasons. In the case of Pilipinas Shell Petroleum Corporation versus Romars International Gases Corporation, the Supreme Court stated that the wordings of this provision, itong phrase na compelling reasons, is of a mandatory nature. requiring a statement of compelling reasons if the application is filed in a court which does not have territorial jurisdiction over the place of commission of the crime. Example of a compelling reason. Based on verified intelligence reports, one of the court employees in the court where the police officers were supposed to apply for a search warrant was found to be an accomplice of drug lord X, the person subject of the application for a search warrant. Here, the police officers may apply in any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. Let us say the place where the dangerous drugs are stored was or is in a house in Ormoc City. The court that has territorial jurisdiction over Ormoc City is the Regional Trial Court of Ormoc City or the Municipal Trial Court in cities of Ormoc City. But if it is found out that a court employee or any person working in the Hall of Justice is found to be connected with the person subject of the search warrant, and in order that the application for a search warrant or the search warrant itself will not be leaked to the person connected with the person subject of the warrant, the police officers in that situation may apply for a search warrant in another court that has no jurisdiction over the place where the offense was committed. So, the police officers may file an application for a search warrant in Tacloban City. And that is what? A compelling reason which is allowed under the rules. What are the requisites for the issuance of a valid search warrant? Rule 126 Section 4 states, a search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. Requisites. Based on the statement in Rule 126 Section 4. Number 1, probable cause is present. Number 2, such probable cause must be determined personally by the judge. Number 3, it must be in connection with one specific offense. Number 4, the judge must examine in writing and under oath or affirmation the complainant and the witnesses he or she may produce. Number 5, the applicant and the witnesses testify on the facts personally known to them. And number 6, the warrant specifically describes the place to be searched and the things to be seized. So, those are the requisites based on the rule found in Section 4, Rule 126. Let's talk about probable cause in connection with the issuance of a search warrant. Probable cause are or is such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place sought to be searched. Probable cause exists if a practical, common sense evaluation of the facts and circumstances show a fair possibility that dangerous drugs will be found in the asserted location. Sufficient information must be present to allow a judge to determine probable cause and his action cannot be a mere or should not be a mere ratification of the bare or unsubstantiated contention of others. This was decided in the case, or this was the pronouncement of the Supreme Court in the case of Abuan versus People. The phrase, such probable cause must be determined personally by the judge. What does it mean? In People versus Choi, the Supreme Court said that the searching questions propounded to the applicant and the witnesses depend largely on the discretion of the judge. Although there is no hard and fast rule governing how a judge should conduct his examination, it is axiomatic that the examination must be probing and exhaustive. Kasi judge nga eh. Okay? Not merely routinary, general, peripheral, perfunctory, or pro forma. The judge must not simply rehash the contents of the affidavit but must make his own inquiry on the intent and justification of the application. The questions should not merely be repetitious of the averments stated in the affidavits or the positions of the applicant and the witnesses. If the judge fails to determine probable cause by personally examining the applicant and his witnesses in the form of searching questions before issuing a search warrant, grave abuse of discretion is committed. The phrase, it must be in connection with one specific offense. What does that mean? In Philippine Long Distance Telephone Company versus Alvarez, the Supreme Court had occasion to rule that if the caption and or body of the search warrant show that it is issued for more than one offense, like for example, the warrant indicates that or shows that it is for violation of RA 9165, but in that same warrant, it was also issued for violation of RA 10591 on illegal possession of firearms, then the same becomes a scattershot warrant and therefore void. The one specific offense requirement reinforces the constitutional requirement that a search warrant should issue only on the basis of probable cause. Since the primary objective of applying for a search warrant is to obtain evidence to be used in a subsequent prosecution for an offense for which the search warrant was applied, a judge issuing a particular warrant must satisfy himself that the evidence presented by the applicant establishes the facts and circumstances relating to this specific offense for which the warrant is sought and issued. In the landmark case of Stonehill versus Jokno, the Supreme Court, in declaring as null and void the search warrants which were issued for several laws, violations of laws like violation of central bank laws, violation of the Traffic and Customs Code, violation of the Internal Revenue Code, and violation of the Revised Penal Code. So there was only one search warrant and it contained or it was issued for several violations of law. How did the Supreme Court decide on the validity of the said search warrant? The court said, in other words, no specific offense had been alleged in said applications. The averments thereof with respect to the offense committed were abstract. As a result, it was impossible for the judges who issued the warrants to have found the existence of probable cause, for the same presupposes the introduction of competent proof that the party against whom it is sought has performed particular acts or committed specific omissions violating a given provision of our criminal laws. As a matter of fact, the applications involved in this case do not allege any specific act performed by herein petitioners. It would be the legal heresy of the highest order to convict anybody of a violation of central bank laws, traffic and customs laws, internal revenue code, and revised penal code without reference to any determination, or rather without reference to any determinate provision of said laws. So tingnan mo yung search warrant na in-issue in the case of Stonehill versus Jokno. There were many alleged violations committed, and at the same time, there was no specific provision of law described or mentioned in the search warrant itself. Like for example, the search warrant was merely issued to search for personal property in violation of customs laws. What specific provision in the Tariff and Customs Code was being violated by the person subject of the warrant? That was the point, in the case of Stonehill versus Jokno, that it became impossible for the judges, or it will already be impossible for the judges to properly determine probable cause, because there was no mention of a specific provision that was violated. This statement, the judge must examine in writing and under oath or affirmation the complainant and the witnesses he or she may produce. What does that mean? The phrase in writing there means that the examination must be recorded, meaning to say there must be a stenographer during the examination of the applicant and the witnesses by the judge that will record the searching and probing questions made by the judge or propounded by the judge to the applicant and the witness or witnesses the applicant may have or may produce during the said examination. And the phrase under oath there means a solemn formal calling upon God to witness to the truth of what one says. What about the phrase, the applicant and the witnesses testify on the facts personally known to them? Here, in the case of People versus Gabiosa, the Supreme Court said that there is no need to examine both the applicant and the witness or witnesses if either one of them is sufficient to establish probable cause. When the affidavit of the applicant contains sufficient facts within his personal and direct knowledge, it is sufficient if the judge is satisfied that there exists probable cause. In the case of Laod versus People, the Supreme Court, in describing the phrase, the warrant specifically describes the place to be searched and the things to be seized, the Supreme Court said that a description of a place to be searched is sufficient if the officer can ascertain and identify the place intended and distinguish it from other places in the community. Thus, a search warrant may be said to particularly describe the things to be seized when the description therein is as specific as the circumstances will ordinarily allow, or when the description expresses a conclusion of fact, not of law, by which the officer may be guided in making the search and seizure, or when the things described are limited to those which bear direct relation to the offense for which the warrant is being issued. We will now discuss the rule on the use of body-worn cameras in the execution of search warrants as mandated by, as I said, Administrative Matter number 21-06-08-SC. However, for a complete discussion of the said rule, I have already uploaded a separate video on such topic which you can access anytime on my YouTube channel. Let's go to search warrants. Ano ba ang rule with respect to search warrants? When applying for a search warrant, the applicant shall state in his application the availability or unavailability of body-worn cameras to be used in the implementation of a search warrant. So nakastate na dun mismo sa application for a search warrant kung available ba or hindi available ang body-worn camera. Now, in case of the unavailability of these body-worn cameras, the applicant should request, or may request for the authority to use alternative recording devices. This is akin to a motion, di ba? Kung warrant of arrest, dapat mag-file ng motion ang law enforcement officer to allow them to use in lieu of a body-worn camera another alternative recording device. But in the case of search warrants, doon mismo sa application, doon mo na ilalagay yung request mo na gagamit ka ng alternative recording device kung wala kang body-worn camera na magagamit during the implementation of the search warrant. Now, what if the judge finds probable cause for the issuance of a search warrant? What happens next? The judge, of course, shall issue the search warrant kasi merong probable cause. And such search warrant must include an order requiring the use of at least one body-worn camera and one alternative recording device, or a minimum of 2 devices, or such number as is necessary to capture and record the relevant incidents during the execution. What shall the law enforcers do during the implementation of the search warrant? Actually, the same lang, as with what the law enforcement officers should do during the implementation of a warrant of arrest. So I will just give you a rundown. Number 1, at least one body-worn camera and one alternative recording device should be worn by the members of the team. And if a body-worn camera is not available, at least 2 alternative recording devices must be used. Third, whether it is a body-worn camera or an alternative recording device, dapat nakalagay siya in a conspicuous location sa katawan ng law enforcement officer para ma-maximize yung ability ng camera na ma-capture yung pangyayari. And then, both the video and audio recording functions of the cameras must be activated as soon as the law enforcement team arrives at the place of the search. So, kaparehas lang, as with what the police officers should do in the implementation or during the implementation of the arrest warrant. Number 5, the camera shall not be deactivated until the search has been fully concluded and the officers conducting the search have left the premises and returned to the police station. Number 6, when conducting a search by virtue of a search warrant, the officers wearing the body-worn cameras or alternative recording devices shall, as early as practicable, notify the lawful occupant of the premises to be searched that the execution of the search warrant is being recorded and that they are conducting a search pursuant to a search warrant issued by a court. What shall the law enforcement officers do next after the implementation of the search warrant? Number 1, within 10 days after the issuance of the search warrant, the officer or officers must make a return of the search warrant and forthwith deliver the property seized. Saan nila i-deliver? To the judge who issued the search warrant, together with the return. And then, aside from the return, the property seized, dapat they must also submit an inventory of the property seized, and such inventory must be duly verified under oath. This is so provided not in these rules but in Section 12, Rule 126 of the Revised Rules on Criminal Procedure. Number 2, the law enforcement team must store all the recordings from the body-worn cameras or alternative recording devices in an external media storage device and simultaneously deposited in a sealed package with the issuing court. So katulad din ng warrant of arrest, no? Yung lahat ng recordings dapat i-store in an external media storage device. Tapos yung storage device ilalagay sa isang sealed package, no? Tapos isasubmit doon sa court that issued the search warrant. Together, of course, with the report, the property seized, and the inventory, which should be verified, duly verified under oath. Number 3, the return of the search warrant shall also be accompanied by affidavits of the officers whose body-worn cameras or alternative recording devices were used to capture the proceedings. So, ang dami ng requirements, no? To repeat, the report, the affidavits, the property seized, the inventory, tapos yung recording. This will be all submitted before the judge that issued the search warrant. Now, what shall be contained in the affidavits? The same matters as in the case of the affidavits submitted pursuant to the warrant of arrest are to be stated in the affidavits submitted pursuant to the search warrant. What shall be contained in the affidavits? Number 1, the date, time, and place of the recording. Number 2, the manner by which the recording was taken and stored. Number 3, if a body-worn camera is unavailable, the fact of its unavailability and that a resort to alternative recording devices was necessary, and the circumstances detailing the non-activation, interruption, or sudden termination of the recording. Number 4, the fact that persons subject of the recording were notified of the use of body-worn cameras or alternative recording devices. Number 5, the date, time, place, and other circumstances surrounding the first instance of retrieval or download of the recordings from the cameras. Number 6, the names and positions of the persons who had possession of and access to the recordings, including the details of such access from the time of their taking until their deposit with the court. Number 7, the fact of reduction. Reduction means editing, censoring, or obscuring. So, dapat nakalagay sa affidavit yung first 6 na matters na sinabi ko na dun sa previous slide. Tapos ito, dapat nakastate din sa affidavit yung kung meron bang reduction na ginawa, no? Editing, censoring, or obscuring, reduction of personal identifiers appearing in the recording. Also, it must be stated in the affidavit the special circumstances justifying such reduction and the details redacted. This is also important because in the next few slides, we will be discussing what are the allowable instances of reduction or editing or censoring. Although, required talaga na dapat continuous yung recording ng video camera from the time of the arrival of the place at the place of arrest until after the accused is brought to the nearest police station, merong mga instances na allowed yung kapulisan natin na i-edit, i-censor, or i-obscure yung mga personal identifiers that would appear or might appear in the recordings. Number 8, a certification that both unredacted and redacted files containing the recordings are submitted to the court. This is also important para merong comparison. ano yung na-redact, ano yung mga instances or parts ng video na inedit, tapos dapat isubmit din yung unedited na recording. Number 9, the names and positions of the officers who will be delivering the recordings to the court. Number 10, the reasonable ground in case of non-compliance with any of the requirements on the use of body-worn cameras or alternative recording devices, including all acts undertaken showing genuine and sufficient efforts exerted to ensure compliance with these rules. So, ang purpose lang nito, why all these matters should be contained in the affidavits of the law enforcement officers, is to preserve the integrity of the recording. Just like RA 9165, no, the purpose of Section 21 is to preserve the integrity of the drug seized from the person arrested. Now, take note that in case of death, physical disability, resignation, or severance of ties with the agency of the officers whose body-worn cameras or alternative recording devices were used in the execution of the warrant, any member of the arresting team shall make or can make the affidavit. What happens if death results from the execution of the search warrant? In such a case, the law enforcement team must submit to the court that issued the search warrant an incident report detailing the implementation of the search, the reasons why such death occurred, and the result of related inquest proceedings, if any, including possibly those against the officer or officers causing the death, together with other relevant documents. Now, ang kinasosurpresa ko lang is walang ganitong rule with respect to a situation where death results from the execution of a warrant of arrest. Pero in this case, if death results from the execution of a search warrant, meron na dapat mag-submit ng incident report. What about the judge who issued a search warrant? What shall he do after such report or return is filed? Kaparehas lang no ng dapat gawin ng isang judge whenever he receives a report or a return after the execution of the warrant of arrest. So here, after the execution of the search warrant and after a return of such warrant is filed, the judge must ascertain if the report or the return is accompanied by the required affidavits. Of course, aside from the requirement of submitting the property seized, the inventory, and the recordings. Now, if the required affidavits are not submitted, the judge must issue a show cause order against the officer responsible and require him to submit the required affidavits. And if the officer fails to comply with the show cause order, the judge may cite him for contempt of court. What is the effect of the failure to observe the requirements for body-worn cameras on the search conducted? Under Section 7, Rule 3 of these rules, the failure to observe the requirement of using body-worn cameras or alternative recording devices without reasonable grounds during the execution of the search warrant shall render the evidence obtained inadmissible for the prosecution of the offense for which the search warrant was applied. Take note that with respect to the failure to observe the requirement of using cameras in the execution of a warrant of arrest or in the execution of or in effecting rather of a warrantless arrest, it will not invalidate the arrest itself. But with respect to the implementation of a search warrant, the failure to observe the requirement of using cameras during the implementation of the search warrant will render the evidence obtained by virtue thereof inadmissible for the prosecution of the offense for which the search warrant was applied for. So there is a difference here, no? In the case of arrests made by virtue of an arrest warrant or an arrest effected through a warrantless arrest, kahit na walang body camera or alternative recording device na ginamit during the implementation of the arrest, it will not invalidate the arrest itself. But in the case of a search warrant, if there is no or there are no reasonable grounds that would justify the failure to observe the requirement of using body-worn cameras or alternative recording devices during the execution of the search warrant, to repeat, it will render the evidence obtained by virtue of the search warrant inadmissible. What happens if a law enforcement officer fails without reasonable grounds to adhere to the requirements during the execution of the search warrant, or he intentionally interferes with the body-worn camera's ability to accurately capture audio and video recordings of the search, or he manipulates such recording during or after the search, or he fails to timely file the affidavit as required? In such a case, the law enforcement officer may be held liable for contempt of court without prejudice, of course, to any administrative, civil, or criminal proceedings that can be or may be instituted against him for the same acts or omissions. And of course, the law enforcement officer will not be liable if the camera or the device malfunctioned and such officer was not aware of the malfunction prior to the incident. Again, this is somewhat a shaky provision because it can be abused by the law enforcement officer concerned. He can always say na nag-malfunction yung body-worn camera niya or yung alternative recording device, which prevented him from recording the relevant incidents during the implementation of the search warrant. What is the remedy in case the search was conducted in violation of these rules? If the search was done without the use of body-worn cameras or alternative recording devices, and the failure to use such cameras is without reasonable ground, a motion to suppress evidence may be filed. Where should it be filed? It may be filed in the court that issued the search warrant, or it may be filed in the court where a case was eventually filed against the person subject of the search warrant. Now, a motion to suppress evidence may also be filed with respect to the search incidental to the execution of a warrant of arrest, when such arrest was without the use of body-worn cameras or alternative recording devices without reasonable ground. Is the consent of the person arrested or affected by the search required before the recordings can be used in a court proceeding? The answer is yes, and the same shall only be asked in the presence of a counsel of the choice of the person arrested or affected by the search. So, nasa sa desisyon ng person arrested or person affected by the search whether i-allow niya na gamitin yung recording during trial or in a court proceeding. If after being asked in the presence of counsel, the person arrested or affected by the search remains silent, then such silent response will be tantamount to giving consent. So for example, the person arrested was asked if he is giving consent that the recording be used during trial. If he does not give a response, no, silent response at the very least, it will be considered as him giving his consent. Now, if the person consents or remains silent, the recording may be used by him or even against him in a court proceeding. Now, kung ako yung person arrested, tapos alam na alam ko na the arrest was farcical, no? Hindi totoo, no? Then it would be favorable on my part because, of course, I would not allow the showing of the video or the recording if alam ko na pinilit lang ako to act as if I was being validly arrested without warrant, assuming that is the case, no? And why do I say that? Kasi yung person arrested will be given the chance to access the recording prior to its submission to the court. So that is the reason why kailangang merong consent dapat, no? Kung ayaw pumayag ng person arrested or affected by the search, then hindi pwedeng gamitin yung recording during trial or during a court proceeding. In the case of a minor, the consent shall be secured from his parent or guardian. However, if the recording captures an incident resulting in death or an assault against law enforcement officers, the recording may be used in court even without consent from the person arrested or affected by the search. So take note of that. Can the recordings be used in lieu of the testimonies of the persons subject of the recordings or that of the law enforcement officers? The answer is no. Why? Because they are merely supplementary to the testimonies of the persons subject of the recordings or that of the law enforcement officers. They shall not be deemed as substitutes for the presentation of witnesses. Are there instances where the cameras can be turned off during the arrest or search? The answer is yes, and these instances are as follows. Communications between law enforcement personnel unrelated to the arrest or conduct of the search. Encounters with undercover officers or confidential informants. Or when law enforcement officers are on break or otherwise engaged in personal or non-work related activities. Inside restrooms, locker rooms, or other places where there is a similar expectation of privacy and there is no legal reason to be present unless the premises itself is covered by the search warrant. In locations where individuals have a reasonable expectation of privacy, such as in residences, unless the recording is being made pursuant to a valid arrest or search warrant of the individuals or locations. Strip or body cavity searches when such is necessary as provided for in the warrant itself, the search warrant. Conduct of tactical planning before conducting the search or the arrest, confidential yan. Privileged communications between the subject of the recordings and other individuals such as attorneys, members of the clergy, peer support counselors, and medical professionals. So for example, habang kumukonsulta yung person arrested sa kanyang attorney, dapat naka-turn off yung camera, no? To uphold the privileged nature of the communication. And such other circumstances as may be provided by the court that issued either the warrant of arrest or the search warrant. Another important question. What about the use of cameras by persons other than the law enforcement officers who also happen to witness an arrest or search being made? Are they subject to these rules? The answer is no. Hence, the persons who happen to record the arrest or search will not be liable for contempt even if they do not submit the same to the data custodian, or they happen to release the recording to other persons, including the media, or such recording is used in a court proceeding without the consent of the person subject of the arrest or search. So, ang situation being contemplated here is a situation wherein a private person who is not a law enforcement officer is able to record the incidents, the relevant incidents during an arrest effected by a law enforcement officer. Yung recording na yun, hindi yun subject ng rules. Ang subject lang ng rules is yung recording being made by the law enforcement officer himself. So, yung separate recording na yun na ni-record ng isang private individual, it can be presented in a court proceeding even without the consent of the person arrested or the person affected by the search. It need not even be submitted to the data custodian. And it can even be subject of disclosure. No? It can be released, no, to other persons, including the media. Another question, are such recordings admissible in evidence? The answer is yes. To be admitted as evidence, they only need to be presented during trial and authenticated by the person who captured the recording.